So we are really excited to be here just about an hour north of the Beltway to talk about what is happening in Washington. If you are like me and you get those phone alerts, it seems like every 25 minutes it's breaking news, and I happen to get the Washington Post and the New York Times breaking news, and sometimes one of them comes in first, and I've actually started having fun comparing how they, in the same 30 words, say the same thing, but differently. So everything is breaking news, right? We are living in a time of breaking news. We have a very unconventional president and unconventional administration. Times are changing. That doesn't mean, as I tell many people when I go to my neighborhood barbecues, it doesn't mean it's all bad, particularly in the environmental area. There's a lot of really interesting things happening. There's a lot of good change happening, and there's a lot of thought going into some of the changes that are being made. I know working with the states, we have seen a great opportunity through the administrator's invitation to talk about cooperative federalism and the role of the states as an incredible space to step into with 40-year-old state environmental programs that have been delegated, that are mature, and that are running well. And we are having robust, deep conversations, not only as my organization ECOS with EPA, but also states with their regions and with their state counterparts on what does it mean to be a delegated state in this environmental system. What are the 3 R's? The roles, the responsibilities, and then how do we allocate the resources? So it's a question of who does what, who is most capable and most effective at doing what, and then how do we sort of allocate those resources to those different entities, to the states, to the federal government through EPA and other agencies that have environmental responsibilities. So this is a great time for those of us who have been doing this for a long time. Raise your hand if you have been thinking about the system of environmental protection in which we live for at least 5 years. Keep your hand up if you've been thinking about it for 10 years. Keep your hand up if you've been thinking about it for 15 years. Keep your hand up if you've been thinking about it for 20 years. 25, 30, 35. We still got 1, 2. All right. So this is an amazing time to explore ideas that people have been thinking about. So let's highlight a few things that have happened and how we're going to move into this panel. We have seen executive orders about 2-for-1 regulations, and people are asking questions. What does that really mean? We've seen executive orders on streamlining permitting, executive orders on regulations that are out of date, and even a recent report from an executive order from the Department of Commerce that looks at manufacturing and the permit process and how we're going to accelerate manufacturing in this country. This is an exciting time. We've seen steps taken to look at the Clean Power Plan, steps taken to look at the Waters of the U.S. rule. And then even this week, and you'll hear from one of our speakers, a memorandum from Administrator Pruitt on sue and settle and the rule of law. So this is a heady conversation and a good time for us all to be in this room. We even have seen some amazing leaders be brought into the administration. One of my former colleagues from the state administrators, Henry Darwin, who is now the Chief Operating Officer of EPA, is bringing the concept of lean process improvement, looking at the steps that it takes to get things done. And are we taking too many steps? How can we have an equally protective permit, but maybe do it in a more effective and streamlined way? There was an example one day that I heard from a colleague. They were watching one of their state employees at the state agency walked in and wrote in a book in pencil, in a book, logged, and the director said, "What are you doing?" And the staff member said, I'm logging in this permit application. And he said, "Why are you logging in a permit application?" And she said, "Well, because we've always logged in a permit application." He said, "Well, what happens after you log in this permit application, this book?" She said, "Oh, nothing. Okay, these are the kinds of things, everything from the very basic, why are we still doing certain things, to how can we do things better. So this is a time that I think we should embrace and all bring our good thoughts and ideas together. So let me tell you about this amazing panel who are each going to talk for about 10 or so minutes about how they see their views from inside the Beltway, where they sit, and where you sit gives you a lot of perspective. And we have 3 very different perspectives, and we're excited about them. First, we have Susan Boudin, Senior Advisor to the Administrator. Susan comes with a very rich background from working on Capitol Hill for many years. She also worked in private practice. And again, her full bio is on the app. She also previously served in an administration as the Assistant Administrator for what was then OSWR, Office of Solid Waste and Emergency Response, for those who have fondness for acronyms. It is now OLEM, the Office of Land and Emergency Management. So Susan has a wide range of experience from Capitol Hill, from private practice, from working for the administration, and now serving as Senior Advisor to Administrator Pruitt. So welcome, Susan. To Susan's left is Kevin Manoli. Kevin is the Acting General Counsel of the U.S. EPA. We are thrilled to have Kevin here. He is a career lawyer at EPA and is filling a very important role as the Administrator Pruitt and his team are looking for their political nominees and working through confirmations. Kevin is keeping many trains moving forward in the Office of General Counsel, and since this is a legal audience, it would be good to hear from Kevin. So welcome, Kevin. And then third, we have Tina Richards. Tina is counsel to the House Energy and Commerce Committee, the subcommittee on environment. I've worked with Tina for many, many years in this capacity. She has worked on Brownfields, she has worked on TSCA, she has worked on Superfund. The list goes on. And Tina has a particularly challenging job this morning because she is our Hill representative. Now, one person cannot possibly represent everything that is happening on the Hill, so please remember, Tina works on the House side and she works for a committee with a particular jurisdiction, but I know that she might have some thoughts about things that fall outside that committee's jurisdiction, but we'll try and respect the venue from where she comes and the experience that she brings. So hopefully all of us will have a chance to bring you inside the Beltway. How many of you actually live and work inside the Beltway? Okay, so you guys will be like our truth meter. You can see what you think and what you hear, if you think this makes sense. And hopefully you won't be shy about asking questions when we have some time for Q&A. We are going to take a moderator's privilege. I have some questions for them that we'll address after they talk, and then we'll open it up to all of you before we conclude. So with that, I'm going to turn it to Susan. I think our speakers are going to stay mostly seated. Kevin has some slides. We're going to just roll right into this. So Susan, the floor is yours.
Is this on? It is. Well, thank you, Alex. I'm really happy that you didn't read our bios. I spoke on a panel at an event once, and the bio was X years this, X years that, X years that, and one of the audience came up to me afterward and said, well, now I know how old you are. It's like, oh, good. Although Alex just did that with our how many years we've been thinking about environmental law and environmental programs. No, it's a pleasure to be here. Tina is the sole Hill representative. Alex asked me to do this months and months ago. A lot of planning goes into these events. And at that time, I think I was your other Hill rep because I was chief counsel for Senate Environment and Public Works Committee. But things change and things happen quickly in DC. And so now I'm in the office of the administrator at EPA. And so I'm speaking from that perspective, although I could probably answer Hill questions too. It's a really exciting time to be at EPA right now. Administrator Pruitt is reimagining EPA to get the agency to focus on real environmental results, cleaner land, cleaner air, cleaner water. And you can see that focus in the draft strategic plan that EPA released for public comment on October 2nd. For example, if you look at that plan in the enforcement area, the plan is asking EPA to ask ourselves, how successful are we in achieving compliance with environmental laws, in making sure the regulated community is achieving compliance, or if they're not, getting them back into compliance with our laws. Now, to achieve these real environmental results across the agency, he's asked every office to go through a lean exercise. Alex mentioned that's being headed up by Henry Darwin, the new Chief Operations Officer. And that, as she stated, that exercise is to kind of break down the steps, break down the process, and focus on what are the actions that are most important to our stakeholders, to the public. What are those actions that need to be done to get results, and then how can they be more efficient? How can we do them more quickly? Now, overall, I want to touch on, I think, maybe 5 areas. I'll do this quickly. But compliance assistance, accelerating Superfund cleanups, streamlining approvals, and then cooperative federalism. Now, on compliance assistance, that one of the most important tools to achieve environmental results is to help people comply. I mean, obviously the goal of our federal environmental laws is protection of human health and the environment, but you need people to comply with them to achieve that goal. Now, EPA has a lot of tools: compliance assistance, informal enforcement, and formal enforcement actions. And there are a lot of, again, there's a whole toolbox, a lot of different ways to achieve these. Like, for example, if there's a small violation during an inspection, that can be cured. In many cases, that can be cured while the inspector is still there. You can bring a facility back into compliance that same day. Self-reporting is another tool. EPA does still have an audit policy, even though we haven't heard much about it in recent years. That includes a new owner policy that will help new owners rectify problems that pre-existed their ownership. And that policy was launched in 2008. I have to say, I feel like I'm a pretty keen observer of the agency. I didn't know about it, but it's there, it's on the website, it's something that you may want to take a look at. Just this month, Administrator Pruitt launched another tool called Sector Strategies. Now, this is actually a relaunch of something that had been in place at the agency before. It started back in the 1990s under the Clinton administration, and it was called the Common Sense Initiative. It was rebranded back in 2003 as Sector Strategies, but in 2009 it was abandoned. Administrator Pruitt has resurrected this program, and the purpose, as was then, is now, it's to create effective solutions to environmental problems that involve collaboration, communication, and, of course, compliance assistance. Because, again, by helping the regulated community understand what they're supposed to do, then we all can improve human health and the environment. Again, the goal is compliance. The second topic I want to talk about is an enforcement, essentially direction policy, and that's focusing on the most impactful cases and punishing bad actors. Administrator Pruitt has made it very clear to his staff that he wants real results that result in environmental improvement, and that means aggressively enforcing environmental laws against the people who violate it. And it doesn't matter whether it's Volkswagen, criminal action, or whether it's a smaller facility who's dumping hazardous waste in the back 40. Intentional violations of the law won't be tolerated. He's made that very clear. Another focus of the administrator is Superfund. He's made it very clear that he wants to accelerate cleanup of toxic waste sites. And to achieve that goal, that means getting private parties to fund the cleanup. Now, that means people who are responsible for the contamination, the potentially responsibility parties for all your Superfund folks. It also means getting volunteers and investors and redevelopers to fund cleanup. But again, getting the private sector into that, increasing their participation in that process. To achieve this goal, the administrator established a Superfund task force, and in July of this year, that task force reported back to the administrator with a report that outlines 42 recommendations, again, on how to accelerate Superfund cleanups. On the enforcement side, again, that was trying to get volunteers to do cleanups. On the programmatic side, the administrator has tried to accelerate cleanup decisions by taking the largest remedy decisions, the ones that are $50 million or more, and taking that back at the administrator level. So he is making the remedy decisions, he's signing the rods. And that increased attention to Superfund has already made a difference. Just this month, the administrator selected the remedy for the San Jacinto River Superfund site in Texas, and that decision was made, it was actually accelerated. That decision was made earlier than had originally been planned because he wants to accelerate the decision so he can accelerate the removal of the waste and then accelerate the protection for those local communities there. There are other recommendations of the task force, for example, on the enforcement side, look at prospective purchaser agreements, updating the prospective purchaser work agreement models, and then also reaching out to the investor community, again, to talk about how they can help contribute to cleanups and yet use these enforcement tools and how they can achieve protection. And then another thing that the task force is recommending is an update to the common elements guidance. That's under the Brownfields law from 2002. It's for bona fide prospective purchasers. They need to understand what they have to do to keep their status as a bona fide prospective purchaser, because that's what protects them from liability for the contamination they didn't cause. And so there's a whole guidance and a series of steps that people need to do to keep that defense, that liability protection, and making that as clear as possible helps people feel comfortable stepping in and taking ownership of a site. And then finally, there's a whole group of folks out there who frankly, Congress didn't, because I'm dating myself, but Congress didn't think about when, in the 2002 Brownfields law, there was a lot of discussion about protecting prospective purchasers, thinking that people who have a profit motive, they can come in, they can invest in a new property, they can buy it, they can clean it up, that's great. But there's another group of folks out there who actually want to clean up sites in a purely altruistic way. It's not a profit motive, but so they don't want to take ownership, and they don't actually have the liability protections that the BFPPs do because they are good Samaritans. And so it's been an ongoing kind of struggle and dialogue about how to extend those same kind of liability protections to the good Samaritans, since they don't take ownership, and so they don't technically meet the standard of a BFPP. But again, that's something the task force is recommending that the agency look at. I think there is some look at that in Congress as well. Another goal is streamlining permit approvals. You heard Alex mention that. That is certainly a goal in the agency's strategic plan. That also is implementation of the Title 41 of the FAST Act, which was the highway bill. Of course, big highway bills always carry other things as well. Title 41 was the Federal Permitting Improvement Act. And again, the goal of that is to get permit decisions for major projects more quickly. The President issued Executive Order 13807 recently. That's the establishing discipline and accountability environmental review and permitting process for infrastructure projects. So the agency's strategic plan talks about EPA's role in that. That's something that I've worked on in my past life on the legislative side, whether it's the Corps of Engineers programs, the federal highway programs, and of course the FAST Act, the Title 41 issues. And just looking, having done oversight on these issues, it's, if you look at what's been enacted into law, if you look at the various statements that are made on it, it's not about changing underlying environmental standards. It's about making decisions more quickly. It's about collaboration, communication, getting everyone at the table, not giving people second bites at the apple. It's managing the process, it's managing people so that you can get decisions more quickly. And so if you look at all of those different areas, that is what you see. And then finally, I'm going to talk about cooperative federalism. That's something that there's a lot of discussion about at EPA these days. That is Administrator Pruitt's overarching approach to environmental protection. That is already in almost all of our environmental statutes. There's a cooperative federalism structure where we have national standards but state implementation. How that's carried out changes from time to time, and I think that that Administrator Pruitt wants to reset that relationship and really reset the partnership with states, because states are, in fact, the co-regulators. Now, that's going to be an evolution. You don't kind of change your approach overnight. It's a shift in approach. It's a shift in attitude. Again, it's people. You know, it's not changing laws. It's changing how people approach things, and that's hard. But there's a lot of discussion about that, a lot of discussion with ECOS, a lot of work groups that have been put together. I'm going to let Alex can answer questions about that. But it's but there's also a lot of different models. I mean, it's like an old truism. There's no one size fits all. But that's particularly true in this whole cooperative federalism relationship, because different states want different things. You know, whether it's work sharing or sharing the planning, or whether it's asking EPA to step aside and let the states take the lead where they're authorized to carry out the program, other than to ensure national consistency. So again, there's lots of different ways and approaches, and I would expect, it may be slightly different in each state in terms of the relationship and what they want from EPA, or what EPA wants to do to help and to ensure national consistency. So I think we're going to see that dialogue continue and that approach, kind of roll out over time. And I'm going to stop here because I'm sure I'm going way over, and make sure that our other speakers have an opportunity.
That was great, Susan. Thank you so much. Kevin, I know you brought some slides, so we're going to have you up here.
Thank you very much, and thanks for allowing me to be here and participate. When Kelly called me several months ago, I accepted on behalf of the General Counsel, who I knew would be confirmed by this time, but we have not quite gotten there. Tomorrow will be the 9-month mark of my opportunity to be the Acting General Counsel at EPA, which is a pretty great honor. I thought I'd talk a little bit about what I see from my viewpoint in the Office of General Counsel. One, and I'll walk through these in more detail, but the roadmap is that, one, I see the office quite a bit, and I'm going to spend just a couple of minutes introducing our office to you all. Sometimes I think we presume everyone knows everything about us that they should know or that we want them to know, and so I'm going to take just a couple of minutes to make sure that we convey some things this morning. Two, I see Administrator Pruitt's principles. He is my client. It is my job to understand him to the best I can and implement what he wants to the best I can. And so I'll talk a little bit about his opening address to EPA, where he laid out his main principles, and then use the directive that was issued on Monday regarding consent decrees and settlements as a case study to see how those 3 principles that he talked about on the opening day continue to come up in actions that we see him doing in the meantime. And then finally, I'm going to spend just one slide on the other work of the agency. There is so much work that happens that will never be in the news that is great and worth mentioning, and so I'm going to do one slide on that. So, a brief introduction to the Office of General Counsel. We are a lot of lawyers. We're not all lawyers, and we'll talk about that on the next below. But for our lawyers, we take the same oath that any lawyer takes to zealously advocate on behalf of our client. And it is something that we pride ourselves on, that even when our clients change and their priorities change and their perspective changes, we do our jobs to the very best of our ability. We will advocate as strongly for the one side as we would for the other. And so we take this very seriously in terms of who we are as an office and the integrity that we approach our jobs with. We do have in our office the traditional general counsel legal roles, so we do counseling. Every action that the agency takes likely has a lawyer who touches it or is involved in it, and we ensure that we try to help our clients do things in a way that is consistent with the law. We help them advocate either within the federal sector or in administrative sectors, and we assist the Department of Justice in any defensive litigation that we have, because we do get sued quite a bit. But we also have a lot of non-traditional legal roles now. Our universe has expanded a little bit. We are the home of EPA's ethics program and ethics office. I am the designated agency ethics official. We have, as of December 25th, 2016, the External Civil Rights Compliance Office in our office. If you don't know the name of that office, it's the office that does Title VI. A lot of people maybe have heard about Title VI. It used to be, for its previous existence in the administrator's office as part of the Office of Civil Rights. There was a decision at the end of the last administration to relocate that to OGC, and I would say it's been a success, and I'll talk about that on that last slide. But we have those folks in our office now, and we have what's called the Foia Expert Assistance Team. That's a group of people who we can deploy anywhere in the agency to help folks with our most challenging, complex FOIA requests. It's something that was done at the request of Bob Perciasepi when he tasked us to figure out a way to better improve how we deal with our most challenging FOIA requests. So we now have a range of attorneys and non-attorneys. We are, in FY17, 387 people, 230 of which are in headquarters. But we also have 158 people who are FTE that we give to the regions. And it's important to know that we have 10 regional counsel offices and work hard to ensure that we have a one national law office approach to what we're doing. But we are, it's about 60-40 in terms of the percentage of where our people are. And there is a differing roles between the headquarters folks and the regional folks in sort of national scope issues. Our current structure in terms of our leadership, as I said, tomorrow will be 9 months that I've had the opportunity to be the acting general counsel. I have an acting principal deputy, that's the career deputy spot. And we do have 3 political deputies now. We have the senior deputy general counsel is Eric Baptist, Deputy General Counsel David Fatui, and Deputy General Counsel Justin Schwab. Justin was the first person in the door on the Beachhead team and has been with us since that first day, and David and Eric have come later. When our nominee, who is Matt Leopold, is able to complete that process, then Elise will go back to her job and I will get to go back to my job, which is the principal deputy. That position is sort of the chief operating officer of the office, but also handles all issues that are non-environmental. I mentioned litigation. We do have a lot. So looking at our cases, we currently have 444 if you don't consolidate them. And you'll see almost half of those are in the air world. If you practice in environmental law, that shouldn't surprise anyone. But it bears true that air is about 50% and water is about another 0.25%. And then the rest make it up. We're getting a growing industry in FOIA litigation, so this percentages will change. But we have 444 active cases for 230 headquarters employees. And then my final way to introduce us is to share our core values. We spent 3 months last summer going through the summer of 16, trying to understand exactly who we were as an office so that as we went into a transition, we were sure of what we stood for. And we, as an office, came up with excellence, community, work-life balance, integrity, empowerment, and responsibility, and respect. And I try to use those and introduce those to folks whenever I'm talking about our office. And it's particularly important because we're going to talk in a minute about the directive that came out about settlements. And as much as I would try not to use sue and settle, I'm going to have to probably give up on that and use that phrase today. But it's important to know that we in our office take have integrity in how we do our jobs. And as we zealously advocate before our clients, it is hard to hear that people allege that we are colluding with one side or the other. We can hear it in the last 8 years, heard it from one side. I certainly have heard it now from the other side in terms of what we do and whether or not we're doing something that is inappropriate because we settle a case with a party that one political side likes or doesn't like. We take our jobs and take our roles seriously and have a lot of integrity about it. And I wanted to make sure that we conveyed how important that was to us, to all of you. So now to Administrator Pruitt's principles. These are things that we see every day. And as I said, it is my job as his lawyer to understand what they are. And so that's my head there, sitting on the opening day. As he gave his opening remarks, he was sworn in as the 14th administrator of EPA. It's sort of interesting for me to think about that there's only ever been 14. It was February 22nd in what we call our Rachel Carson Great Hall. And 3 things stood out in terms of the principles that he set up on that day. The first was rule of law. The second is process matters. And the third is cooperative federalism. And so those are sort of phrases that you may have heard of. But the question, of course, is what does it actually mean, and what do we think and understand it means to him? So when I think of the rule of law and I try to understand my client and what he wants, I believe that what he wants is that we need to look to the core of the statute for our scope of authority, that we have to understand what was Congress really trying to do at the center of that act, and that's where our authority is. And that if there is discretion to regulate beyond that core, it should be exercised rarely. That's how I try to understand where he's coming from as my client. In terms of process matters, he used a phrase, regulations ought to make things regular, and that you should be able to understand once a regulation goes into place what you need to do in the next several years in order to be compliant with that. They shouldn't be changing in such frequency that they don't actually make things regular anymore. And it's important to him that we follow the process Congress has established for our actions. That is one of the reasons we'll talk about in a minute that the directive came out, in terms of it is important that if Congress set out a path forward or a process, that it is important to him that we follow that. And then third, cooperative federalism. States are accountable for the programs that they assume. Now, accountable is not meaning that they get to not do the job. It actually means they get the respect and get the opportunity to take on the program once it's been designated or delegated to them, but they're also accountable for doing so. But what the administrator expects of us is that if that state is trying to meet their obligations, that it is our roles to help them get there. We are to be problem solvers, is what he said on that first day, not the people who identify the problem and then stop. And so we have tried to understand better if states are really trying, what can we do to help them get to the finish line? But there are instances where the state wasn't maybe trying, and he will hold them accountable. So when we look at a case study, if you didn't know this, on Monday, the administrator issued a directive to our office regarding promoting transparency and public participation in consent decrees and settlement agreements. It's a directive that requires us to do a number of things as it relates to litigation, in particular, the negotiated resolution of any particular defensive environmental case. So it's important, that's the scope. It's defensive cases that are environmentally based, so not your enforcement cases and not your information law or the like. But this is an issue that has been, it's been referred to in many different ways, but sue and settle is the buzzword or code word for it. This concern that people whose rights are being affected or who are being very much impacted by a settlement are not participating in it. That's the ultimate thrust of the concern. And so we got instructions to do a number of things, some of which we were already doing and some of which we could do differently and some of which were new to us. So OGC, the Office of General Counsel, now is obligated under this to provide notices of intent to sue and complaints on our website within 15 days. We do put those on our website now. I can't say that we always meet 15 days, but we will moving forward. We now have to, though, provide notice to relevant states and regulated entities. Some of these provisions are going to require us to figure out exactly how to implement them, but the administrator has tasked us with not simply putting something on the website and expecting others to come and check it all the time. If we know that there are entities that are affected, it is now upon us to inform them of the litigation. And then within 30 days, we have to have a searchable database of all of our existing litigation and all of our obligations under different resolutions that we make publicly available on our website. So anyone will be able to go in and see what we have for obligations coming up that are based upon settlements or consent decrees in the past. The second thing, sort of these three main areas is what I take away from the directive. The second area is the transparency and involvement, participation in the actual negotiations. We've been directed to seek participation and concurrence from relevant states and regulated entities. That's a big change, to seek concurrence, but we don't have to obtain concurrence. It doesn't say obtain concurrence. And in fact, over the last 6 months to 9 months, as we've tried to understand what his needs are, we have done this sort of de facto already. So if we have a state involved that we're working with, we'll say, can you get the state to say whether they like it or not? Because that will help us move this case along. So it seems like a significant change in that, and by saying the words, seek concurrence, but it is something that we identified at the beginning of the administration that was helpful to us to be able to articulate what the different stakeholders thought about it, and that's what this direction is about to do. But it does require us to propose that we publish all of our proposed agreements online for 30 days. If you're a Clean Air Act lawyer, you're familiar with 113G. We do that a lot. Not every statute has those provisions that require that. And while we do it voluntarily in a few places, we don't do it for most of our cases. And so now we will. That will give the public an opportunity, any member of the public, to comment on it and give us information about it. And then finally, there's the third key area is the substance of the agreement, the substance of the negotiated resolution. He made clear that, as consistent with the Meese memo, for those of you who know the Meese memo from the Department of Justice, the substance of the agreement can't enlarge our authority or eliminate our discretion. It is very important to him that we don't bind or give away discretion for future administrators. He does say that we should seek to exclude fees and costs. This is a big change for us. There are provisions that allow for attorney's fees in a variety of statutes, and our instructions now from our client are to seek to exclude them. And then finally, we have to ensure that there is sufficient time for the regulatory process. One of the things that he has identified is that we have often come to him and said, you need to sign this now because the consent decree deadline is X. And he says, well, what if I wanted to reconsider a different option? And we say, you don't have time. And so he wants to, as settlements are reached under his watch, that we don't ever have to say, we don't have time. That we have thought enough and built in enough ways to, if we have to repropose, if we have to do a supplemental proposal, we have the time and the authority to do that. So that's, how does this relate to those first three principles? Well, I look at them this way. I look at the providing notice is really about process matters. He wants people to know that they're involved. Transparency, involvement, those provisions to me speak to cooperative federalism. That if people are going to be impacted, and states are going to be impacted in particular, we should have them participating. And then finally, in terms of the rule of law, what we can do or not do in the substance of a negotiated resolution is an application of what he sees as the law in terms of not expanding it, not giving away our discretion, and ensuring that we provide the time that we need to comply with the APA. So while he doesn't use the words in the directive, to me I can see the tracing of them and how they line up with what he has said since the first day. And then finally, I said my final slide would be just a little bit on the work of the agency, because there is such a huge amount of work that folks don't necessarily see or hear about, and it's just as important to us achieving our mission. And so just quickly to mention, I am so proud of the work that our folks did responding to the various hurricanes and are currently doing in Puerto Rico. That has been a great way for the career and political staff to work together without distinction. And we've always said sort of at some point in the beginning of an administration, there is an environmental disaster or something that requires us all to really be on the same team, and that's the way you really break down any of the divisions that people might talk about or read about in the paper. And this has been a great example of how people have really worked. We had one region, Region 6, Sam Coleman, and is a career leader of that office in an acting capacity. And then Region 4, we had Trey Lyons, who was was a political appointee in the regional, as a regional administrator, I think there for about 10 days before the hurricane hit, and they both did a great job. The second thing I want to mention, if you don't know the Samuel J. Heyman Service to America medals, they are like our Oscars for federal employees. They are amazing. It's an amazing night where they recognize really the most compelling and important work that the federal government has done. And this year, EPA employees won 2 of the big awards. We won, the folks at EPA, although we all take pride in our colleagues, were recognized for the Volkswagen settlement as the Federal Employees of the Year. This organization, the Partnership for Public Service, said that our folks did that work. That was the best thing that came out that year of the government. And then also our urban waters team was recognized as the People's Choice. And so on the voting, we did very well. And then finally, I'll mention the Title VI program, or the External Civil Rights Program. That's a program that we have had challenges in for quite some time. We have now resolved more Title VI complaints this year than we ever have before. And while I'm not going to suggest that every complainant was satisfied with what the outcome was, I can say that there was important improvement in the non-discrimination program in every jurisdiction that we worked with, and meaningful results that came out of that. And that's in part because of the cooperative federalism approach of holding people accountable, but also helping them get there. And so I'm really proud of the work that we've done there, and looking forward to continuing to do that. So with that, I will stop and turn it over to you all.
Great. Thank you so much, Kevin. That was really helpful, especially because the administrator's directive on consent decrees and settlements came out, I think, on Monday morning, and I know I printed it out and carried it around in my bag, and there may be other people out there who have been doing the same thing, so I did read it. Particularly as a graduate of James Madison University, I was happy to see some references to the Federalist Papers in there. But that was a great overview, and I like the connective tissue that I think you and Susan have showed us, that there really is sort of a plan and a vision for how the administrator is moving the agency forward, and it's exciting. So thank you. So now we're going to turn to Tina Richards, who's going to give us a bit of the flavor from one of our other important branches of government, the legislature. So Tina, thanks for being with us.
Thanks, Alex. I work for the Energy and Commerce Committee, which has pretty broad jurisdiction, and I specifically work on the Energy and Environment Subcommittee. And we, with the exception of 2 of the major environmental statutes, the Clean Water Act and NEPA, we have jurisdiction over everything else, the Clean Air Act, Safe Drinking Water Act, RCRA, Circle of TSCA. And so Alex asked me to kind of talk about some of the priorities that we have on the committee and the subcommittee. And one of the things House leadership asked us to do was kind of go through the statutes. Like Alex had mentioned earlier, that a lot of these statutes and programs are 40 plus years old. And so we were tasked with, and I don't know if it would surprise anybody, that a lot of the statutes, the environmental statutes, are not currently authorized. So House leadership had asked us to kind of go through, this has been something we've been working on for a couple Congresses anyway, is just looking through the statutes, figuring out if there was a way to modernize the statutes, bring them into kind of the current regulatory, like what the regulated community needs to make the businesses work better, make more jobs available. We all keep using the buzzwords, jobs in the economy, but we legitimately went through the statute to try to figure out if there were ways to update them and bring them into like this. So they also, leadership tasked us with reauthorizing the statute. So we started with an easy one. We started with TSCA last year. We didn't reauthorize it, but we did completely redo the statute, and I think you guys have a panel discussion on that later today. But this year we are working on reauthorizing the Safe Drinking Water Act and the Brownfields law. We can talk more about that, but we have also been looking at, I think it's sensing a kind of a theme here about the cooperative federalism. The committee has long focused on promoting the state-federal the relationship and figuring out a way that we can best use the environmental programs within the states. I think when a lot of these statutes were first enacted, the state programs were in an infancy, and they have since become like robust cleanup programs and such that we'd like to bring that experience to bear on some of these programs. We've also looked at that with respect to our legislative efforts, most recently with the coal ash legislation that passed last year. The committee is also, one of our key primary roles is oversight of these environmental statutes, oversight of EPA. And again, the state-federal partnership is something that we look at in this context, and most recently we've been doing oversight on the hurricane response efforts, and last week we had the Regional 2, 4, and 6 administrator up, in addition to one of Alex's members from Texas DEQ, and it was great to see the cooperation and the working together amongst the regions and the state and EPA. So one of the buzzwords this Congress, I guess this administration, is infrastructure. So that's also something we've been looking at and trying to sort out, like what of the bills and the statutes within our jurisdiction we can update using the potential, like as soon as the infrastructure package starts to take shape, like what we can fit into that, the larger package. I mean, so some of the things that we've been taking a look at specifically are brownfields. We reported a bill from the committee in June that would reauthorize the brownfields program and make several improvements to the program. T&I, the Transportation Infrastructure Committee, also reported a bill. So where we are with that right now is just currently trying to work through the differences between the two bills that were reported, and hopefully that would be scheduled for floor consideration by the full House soon. Something else that also impacts infrastructure is Superfund. So we have been working with EPA and with the task force trying to sort through like what can be done to speed up the cleanup process. And also one of the things that's of particular interest to the subcommittee is trying to figure out a way to increase the state's role in Superfund cleanups. Like I said, we also are reauthorizing the Safe Drinking Water Act. The last time that was reauthorized was in 1996. And I know there's been a lot of studies done about the aging drinking water infrastructure in our country. And so the bill, we reported a bill in July that reauthorizes that program and makes many improvements to the law, including it authorizes additional money for capital improvements to the drinking water infrastructure. We also have the Clean Air Act as of this Congress. So we've been looking at ways that ensure that the permitting and application of some of the air quality standards has the impact on infrastructure development and on the growth of the economy. We just continue to do oversight on TSCA. So, that's kind of the gist of where the committee is right now.
Great. Thank you all. That was a good overview. And so I'm going to, again, take moderator's prerogative, and we kind of agreed to chat in more depth about a couple of things, and then we'll open it up to you all. So Tina just finished talking a little bit at the end about Superfund, and Susan also talked about Superfund, the task force report. So Superfund and brownfields cleanup is a big priority, and I think it's one of the areas where we really see the connection between economic development and environmental cleanup. When you get one of those sites cleaned up, in fact, Baltimore Harbor is one of the success stories of a Superfund cleanup. There was a former steel facility out there that took a lot of collaboration between US EPA Region 3 and the state of Maryland and many other parties, including the private party that wanted to acquire the property after, I think it was US Steel that was out there. And so really, Superfund needs partnerships, it needs collaboration, it needs a lot of innovation. So let me ask first Susan and then maybe Tina about any further thoughts a little more deeply about Superfund and brownfields.
Sure. Thanks, Alex. Well, accelerating Superfund cleanups is definitely a priority of Administrator Pruitt, and you've seen that with his focus and his creation of the task force and then the task force report. And so the follow-on is that with the 42 recommendations, the agency is implementing those recommendations, and a lot of it is, as I said earlier, about trying to get Superfund cleanups done more quickly by getting the private parties, whether it's the PRPs on the enforcement side or third parties, volunteers, and getting them to help accelerate that process. And so there are a lot of tools to help to use that, to give people comfort, to give them liability protection, but if they're not liable, or to aggressively force if they are recalcitrant, but all those tools can be brought forward. I want to put in one pitch on the brownfields, and that is that Tina mentioned that both House committees with jurisdiction have reported bills The Senate Environment and Public Works Committee also has reported a bill. No, you don't have to apologize to me. But what I want to say is this is the first time in years that all three committees of jurisdiction have reported legislation on this issue. And therefore, I mean, generally I would say I would never bet that a public law would pass. It's really hard to pass a public law. But when you have all three committees of jurisdiction, I would put my money on Brownfields reauthorization this year.
Yeah.
Well, and maybe to that end, Tina, you and I have talked because ECOS has testified on Brownfields. Some of our state commissioners have come in and talked about things that would make the program better. So you actually have been looking at ways to improve, with your members of Congress, what tweaks might really make a difference. Can you highlight a couple of those?
Yeah, I mean, I think everybody agrees that the Brownfields program works pretty well, but I think some of the things that we had heard were like multi-purpose grants as an example. I mean, right now the way it works is that people can apply for one grant and you have to keep reapplying. And so if we create like the multi-purpose grants would create an area and people could get assessment, cleanup, and money to assess, cleanup, and inventory the brownfields within the area. We'd also heard about administrative costs, allowing some small portion of the grant funds to be used for administrative costs. We've got some clarifications of some of the liability protections, in particular the leaseholders, whether leaseholders can qualify for the bona fide prospective purchaser liability protections. We've also, there's like the definition of owner operator in CERCLA right now allows for municipalities that take title involuntarily are not considered owners and operators under CERCLA, so we are making that a little broader to allow municipalities or state units of government that take title voluntarily also to be exempt from the definition of owner-operator, and it's assuming that they don't cause or contribute to contamination. We're not changing that portion of the statute. We've had heard that the limit for cleanup remediation grants was not high enough. It's currently $200,000, so we're increasing that to $500,000. An EPA can waive that up to $750,000. We are also allow nonprofit organizations to be eligible entities as well.
Right, so I think that just listening to that, it reflects the diversity of parties that are involved, like nonprofit organizations. And Susan, you talked a little bit about the Good Sam, the Good Samaritan provisions and so forth. So that's I hope you all are hearing there's a lot of, if you go pull those bills, both from the House and Senate, you're gonna see a lot of really good thought. They say that legislation takes an average of about 10 years to actually get through. And I think that was true for the Clean Air Act. It certainly might have been true for TSCA. And so Brownfields, I don't think we're close to 10, but we may be able to beat the average record because there's a lot of consensus around the kind of change that might be very, very beneficial.
Very bipartisan.
Very bipartisan, exactly. So I'm going to turn this one to Kevin and maybe and then first and then to all. But cooperative federalism, we've been talking a lot about it. And one of the areas, I work with the state environmental commissioners, and we've been talking a lot about the role that EPA has under the statutes to review and sometimes object to state decisions, state permits, to return state analyses. I was talking to one state commissioner yesterday that said that their region approves their penalty calculations. They redo the math on the penalty calculation just to make sure it's right. And so there's a lot of what we call day-to-day workflow between the states and the EPA. And I hear from Administrator Pruitt with this rule of law emphasis, looking to the statutes and what is the role of EPA under the statute to review the state decisions. So maybe you could talk a little bit, since you are in the OGC, how you all are starting to look at maybe the statutes bind us together. I say there's no divorce possible between the states and the US EPA, and even if not a single dollar came from Congress through EPA to the states, we are still happily married. So Kevin, tell us a little bit about, you can stick with the marriage analogy or deviate from that. But.
I will let that go. When the nominee, Matt Leopold, spoke at his hearing, he talked about how Congress didn't just enlist EPA in the mission of our agency it enlisted the states as well and the power that they brought with it. And that's a different way of looking at it than when you call it state oversight. The change in our minds, I think, is we're not Monday morning quarterbacks. We are, if we delegate it to the state, I would say sort of almost like we've divorced in that sense, in that, we have given up the day-to-day responsibility, and we have delegated it and authorized someone else to do that. And we should help them be successful in that, as opposed to try and, as some might have felt it was at different times, felt that we were not helping them, but we were in fact watching over them. It doesn't mean that there aren't going to be times, again, where if a state hasn't done or isn't trying to accomplish what they are supposed to accomplish under the agreement to take over that program, that the administrator is going to look the other way. Title V petitions under the Clean Air Act people are familiar with that. People can petition us to object to state-issued permits. We have granted petitions in this administration. So there are things in which if a state is not doing or not trying, he is going to hold them accountable. But he thinks, and the way we approach it is that we should be figuring out how to help people be successful in the first instance. And so we look at the statutes and the provisions to determine how to understand them in that context, and how to ensure that our role is about ensuring success and compliance with the law in that sense.
Great. Do either of you want to comment on cooperative federalism at all, or we can move on?
Well, as I was listening to Kevin talk, I was thinking about, I actually have an example, and this is going to go back to like 2007, maybe. Last time I was at the agency, I was in Office of Solid Waste Emergency Response. And I remember a situation that came up where there was material that was disposed of in a municipal solid waste landfill in an authorized state. And then the question came forward, and I have no recollection of how it came forward. Was that material solid waste, or was it actually a hazardous waste? And so, the Office of Solid Waste office director at the time was Matt Hale, and his staff looked at it, and then they talked to me at that time as the assistant administrator. And what Matt said was, look, the state has reviewed this. They are authorized to carry out RCRA, which means that they are authorized to carry out their state law in lieu of federal law. It meets all the federal standards. And they've reviewed it, and they say it's not a hazardous waste. It's an authorized state, so the program, the Office of Solid Waste office director, their recommendation was, look, we're going to defer to that decision. It's a really, it's one of those gray areas. RCRA, everyone knows, is not the bright lines. And so we're going to defer to that decision because it's their program.
Well, and I really give the administration some kudos here because I say you can't be fair weather federalists, right? We hear a lot about. I tell my teens, to watch out for those fair weather friends. So, fair weather federalist means that that you support the state sometimes when the state's going above and beyond where maybe the administration might choose to go. And we've heard some great examples from several states that would be considered very, very democratically oriented in terms of their governor and their legislature. And this EPA has supported decisions made by the states, in one case involving some pretty strict water quality standards, and there was a lot of pressure from the regulated industry to see if those could be sort of moderated some. And the decision from the administration under Administrator Pruitt and his team was, if this is what the state did, and the state chose this through a 7-year process, and it's causing difficulty, but this is what the state wanted, why would EPA overturn that? And so I think that that's a really interesting, it is a new way of thinking, a new way of approaching challenges, but it's and it is about people, and I don't think that anyone comes to work with poor intentions. Everyone's really trying to do the best job they can to be protective, but I think the states are kind of enthused about this increase in deference. Kevin?
I mean, the other thing I would say, the last administration tried to do this too. And so one of the things that I think we as career people see is the similarities, even if it sounds really different or if people don't know that their predecessor did it as well. So each one teaches us a little differently, but we spent a lot of time at the end of the Obama administration trying to understand and build those relationships, as you know, with ECOS. And so it would be good if we got to a place where we could get the best of both ideas and not have to sort of make it seem as though it's something new or that the last administration did the opposite and horrible, So I just reflect a little bit on how we can get to that point in our relationship.
No, and there is a good marriage analogy, right? Because it's we're in counseling regularly, and I think that it's true. It takes time and it takes decision by decision to come up with an approach that is iterative. And I agree with you. There were a lot of really exciting initiatives under the prior administration that brought states and the federal government through EPA together, and were very productive, including e-enterprise for the environment, which I'll be happy to bend anyone's ear on at another time. So let's transition a little bit to two more topics, and then we'll open the floor. Infrastructure, and then we're going to talk a little bit about rule of law. So infrastructure is such a big word. I've been to a couple of the White House forums on infrastructure. One of them was on highways. One of them was on waterways. And you sit in the highways one, and people are talking about highways, big highways. And then you go in the water one, and they're talking about dams and locks, and you start realizing, and then in another one, there was discussion about airport runways. And so infrastructure, this conversation, it is a big, big topic. How are you all interfacing with the infrastructure conversation from where you sit? Any order you like?
Currently, really not at all.
Okay.
In my past position, a lot.
Okay.
And I'm not speaking for EPW, I'm not speaking for Chairman Barrasso, but he's been very clear in his public remarks that he is very interested in doing infrastructure legislation, and that in his mind, infrastructure is not just highways or Corps of Engineers projects, but it's also drinking water and wastewater. So that he's got infrastructure writ large.
And so, like I mentioned previously, we don't have jurisdiction over like highways or runways, what you typically think of as infrastructure, but we are choosing to do the more inclusive view, which is drinking water infrastructure, how brownfields and CERCLA can utilize existing infrastructure in addition to promoting the development of new infrastructure. And so the approach that Energy and Commerce is taking is we're just doing piecemeal, portions of what would hopefully soon be a larger package of infrastructure, perhaps even including the more typical infrastructure, roads and highways and stuff like that.
I would say EPA does a ton of infrastructure work. Half of our budget is revolving loan funds that are designed to help states and municipalities build things. So one, sort of understanding how we can better assist them in doing that, but two, there are some new areas. In particular, the Water Infrastructure Finance Improvements Act, WIFIA, gave us a new tool and a new set of money. We have hired, we stole from the state of Maryland, someone who works in that area and is helping us stand up a program for water infrastructure that we haven't had the ability to have before. So that's something that I think the last administration started, and this administration agrees, and there's complete support for it from both sides.
Yeah, and that's certainly something that, in my prior life on the legislative side, the Congress is very supportive of, because it WIFIA leverages so incredibly. It's 60 to 1, $1 federal investment, you can get $60 worth of loans. So it's it's complex, and that's why you have to hire people to do it. But the return on investment has the opportunity to be really great, and it was funded at the end of the last Congress with about $20 million, and then it was in the president's budget. It looks like it's going to continue on and be funded, so that's also very exciting. It was authorized in 2014, but it's getting stood up now.
Yep.
Right, so for those of you who don't know, EPA will become a loan authority, through WIFIA, much the way the states have the state revolving loan funds. One of the things that ECOS has been bringing to the table is the small community concerns. If you listen to the direction that the administration, the president will go with infrastructure, it's using federal funds as the last sweetener to get a project across the finish line. So projects with a lot of local investment, a lot of support, that is the philosophy. Those are the projects that, and then those federal dollars come in and give it that last, shot in the arm to get it going. It's very interesting. One thing that I've heard from states is there are going to be communities that can raise that local capital and that can actually be ready to be proponents of an infrastructure project. They have a tax base, but there are also a lot of communities that are going to be in more distressed situations. And we recently provided the agency with examples of communities that are, we call them almost like unfundable, that they're just not going to qualify for a loan. They really need a grant. They need someone to give them the money to protect human health, particularly on the drinking water side. So I think what'll be interesting in the infrastructure conversation is watching it evolve with the big projects that can get financing and then also some that can't. All right, so the last topic we'll talk a little bit about is rule of law, and certainly for an environmental conference, it's a great topic. You heard from Kevin a bit about how rule of law plays in. I alluded to it in terms of, what is the statutory review obligation of the agency in looking at state programs and state decisions. The administrator has outlined a platform that is very much about legal authority and looking very closely at that legal authority. So would any of you like to comment a little bit about rule of law? And before I turn it, I'll tell you that there was a recent exchange in your materials from Missouri DNR to their Region 7. And it said, Dear Region 7, we've just received the list of facilities that you intend to inspect in our state in the coming year. And in short, we object. We don't want you conducting these inspections in our state. We're a delegated program. We'd like to talk to you about this relationship. And there's been a response from Region 7, which is really, really constructive. And it says to the state, we hear you. And there are situations where we believe EPA should be bringing in the inspections. And we've looked back at our list, and some of the sites that we suggested don't meet those criteria. But some of them do. And so we want to sit down with you, State of Missouri, and talk about that. So I wanted you to know that there's a continued conversation that's very positive around this issue of delegated programs, rule of law, authorities that we're seeing play out. So, rule of law. That goes to Kevin first,
sure,
I think.
I'll kick it off, and I spoke a little bit about how I think it's understood in terms of interpreting statutes and authorities. But there's another component to it that for the administrator, which is deadlines are going to be met. And that's something that we always strive for, that we don't always hit. And so we now have in the proposed strategic plan a strict measure of EPA meeting all of its legal obligations. So if you've ever worked at EPA, your mind is like, there's no possible way, Kevin. And we can all say that now too, because we have a 4-year strategic plan, we've got a way to get there. But it is a breakthrough mindset of we should be complying with the deadlines that we are given by Congress. And we don't know how to achieve that quite yet. That's the work that Henry Darwin is, I am very, very excited about Henry being there and the work he's going to do, because it is understanding each step in the process so that if it ever is stuck, and things tend to get stuck at certain points, we can deal with it. And so you've got a board and you track it and how many days and whether it's on target, and if it's not, you go and deal with that right away. So those things are going to help us get there, but it is the breakthrough goal of complying with all of our legal obligations is hard to imagine, but that's the fun of it in some ways. And it's everything from environmental statutes to we have an initiative to eliminate our Foia backlog by the end of the year. That's an extraordinary goal, and by backlog we're defining it as something filed prior to this year, so a year or more. That's an incredible challenge, and we might not get all of them, but it's important to him that we don't have Foia requests sitting out for that many years. Similarly, in the Title VI context, we are trying to eliminate the backlog and deal with our complaints within the timeframes provided. So I think that's the other half of it in terms of what we understand it to be.
And Kevin did a good job, I thought, talking about rule of law. You're speaking mostly, I think, in the regulatory construct or context, in that Congress authorizes executive branch agencies. Executive branch agencies implement the authority that Congress gave them, and that is rule of law. So you don't expand your authority through regulation. That other side of that is on the enforcement side. A rule of law concept, I think, would include that you don't expand your authority beyond what Congress gave you by imposing essentially regulatory requirements in the context of enforcement. If there are things that need to be done, we should be going through notice and comment rulemaking and applying them nationwide, but and not necessarily in putting new regulatory requirements in the enforcement context. So that's something to think about. It's another kind of twist on what does rule of law mean.
And I would just add, when Alex posed this question to us about rule of law and how does it apply to us, I was thinking, I'm like, how does it apply to Congress? Because following up what you just said, Susan, I'm thinking, Congress writes the laws, agencies interpret and implement them. So I was looking at something, and it was like constitutionality, I guess, was one thing that I came up with, was the check on Congress. And I found a quote that I thought was interesting. It's, if the will of the legislature declared in statute stands in opposition to the will of the people declared in the Constitution, judges ought to be governed by the latter. So I just thought that was an interesting. Mm-hmm. And on the deadline, if you guys could meet the deadlines, that'd be great, because we are reluctant to, as working for to put deadlines in the statutes, just because then when the agencies miss them, then it triggers lawsuits. And
Right.
That's good stuff.
There's a great law review article by Richard Lazarus that I often give to my students when I teach, and it says, it's just an excerpt, but it says, in many ways Congress set EPA up for failure in all the statutes, because it's sort of a series of never-ending deadlines that never stop. They recycle themselves. It's review and revise. It's come back. It's every 5 years, and he writes about it in a way that is I think, empathetic to the agency, but also the fact that you all are really going to try and tackle that, and maybe lean and how you approach the work, and also the resources, if you're being able to deploy more resources towards things like Foia backlog and meeting deadlines.
So of course, resources is a question about where we're going to get more. But what I have hopes for the work that we'll do under Henry is that we'll be able to better demonstrate how we use our resources, and so therefore it may not be as controversial in terms of what you allocate for us. I think there's a lot of people who are able to say that they don't know what happens and things get stuck and they go in a black hole. The ability to demonstrate what we do on a timeline and what every one of us does is, to me, an important step in getting towards a place where people don't doubt what we are worth in terms of our funding. So it's I lost your, what was the other point?
Well, no, I think you got it. I think it's the accountability and the transparency, and that's all in there.
Yes, but it's not going to be done immediately.
Right.
And it's in many ways, I think it's what underlies the whole sue and settle concern and phenomena generally. Those people are mostly concerned about things where we've settled cases where we have missed a obligation under the statute to do something by a date X. That's why we're getting sued in those cases for the most part. And so if we can address that and get in compliance with the timelines, we eliminate those lawsuits in the first place.
Well, I think you can all tell why this is such an amazing panel, and I'm so grateful that they're here this morning. We have about 7 minutes for questions, and I think there are microphones around, and I don't know if I see them or not. So if there aren't, you're going to have to project, and I will repeat the question. So I see one hand there, straight back from me. You're waving. Hello, it's you. You are the first question.
EPA has lagged behind the 3 prior administrations in environmental enforcement, collecting about 12 million, which is about 60% less in civil penalties from polluters. Does EPA plan to ramp up enforcement? Is this a gradual step? And are you concerned that the lack of penalties for violators sends the wrong message to violators, giving them the impression that it pays to pollute?
So I think that you have to understand that any enforcement case that EPA brings is something that is months, often years in the making. So you can't take any snapshot and say, oh, that represents a trend, that represents a focus, because enforcement numbers, and if you go, EPA's enforcement results are published on their website. You can go and look at them. Those, you can see in each program, they go up and down because for example, if you focus on a big, large impact case, that's going to take a lot of years. And then when you complete the action, you get a huge, impactful result. And then you may spend a number of years working on other issues or on building up another big case. So I guess what I'm trying to tell you is you can't look at a snapshot and say that there's a trend. And when you look at the website on the enforcement, you're going to see how it is not, it's not a steady because it takes so long to develop these cases.
Well, and a statistic I've been waiting to have a moment to toss out is that actually states bring 98% of the enforcement actions in the country. So there are several databases on EPA's website that allow you to sort, say for Clean Water Act enforcement, you can sort by federal cases and by state cases. And it's amazing to see the federal line, again, is small because the states are doing 98%. So if you're looking for trends and statistics, I would also take a look at long-term performance, kind of like a stock portfolio. You've got to look at it over time. But don't forget to look at the state actions because they are being brought. We had a question to the left, I think. Someone making their way to the mic or... Nope. Did the person go away? Okay.
No, here.
All right, right here. Go right ahead.
First of all, I appreciate your presentation. I think you were all excellent, and thank you very much. One quick comment I would suggest on your marital analogy, you consider the prenup that exists between the state and the feds called the Constitution. Maybe that matters. But my question is this. We know that there are issues between the state and federal government trying to deal with some level of uniformity for businesses. What about within EPA? There seems to be sometimes less uniformity amongst the regions of EPA than there are between the states. And I guess I'm putting Susan on the hook here to say, is there going to be some effort made to deal with that concept of inconsistency in federal enforcement and federal policy?
So you're making an observation that others have made. EPA is an interesting agency in that it is very decentralized, and the regions have most of the authorities are delegated down to the regional level. And what headquarters does in a lot of cases is set policy. And part of what headquarters does is ensure that regions are implementing the policy. But I'm not going to disagree with your observation, and that it just, like any organization, it requires, conversations and collaboration and working together. And if there needs to be new national policy, it would also mean setting new national policies. Because you're right, the authorities are all delegated down to the regions.
I'm like grabbing the mic from Susan here. Sorry. Well, I wanted to say on that, so states through ECOS talk a lot about we see the regional inconsistencies as well as states. And particularly, let's put it in the positive, we've been focusing on best practices from the regions that we'd like to see more consistently carried out. Here's an example. Some regions sit down quarterly with their states and go over permits. And sort of, EPA has to review and approve these permits and take the Clean Air Act. Look at the permits, look at them quarterly, identify which ones may be high profile, which ones may be controversial, work as a team, sit down quarterly. And another state will say, oh, my region doesn't do that. That would be really helpful. Another region, as I gave the example earlier, provided the state with a list of intended inspections for the year. That doesn't happen in every region. So we are looking at the day-to-day areas that we could focus on that could take good practices from one region and replicate them across another region. So I would say also for the regulated community, if you see a certain regional behavior that you like or a regional practice, I think bringing that forward to headquarters will be a way to sort of get that replicated. There's a new position in this administration. Ken Wagner is the special advisor for state and regional affairs, and he is traveling around the regions and listening and trying to identify some of the things you're talking about. Kevin?
Just one thought in terms of how we got to a place where there's the inconsistency. Everyone really wants consistency that comes with the flexibility that they want for them. And so some of it is we work hard with our partners to be amenable and adjustable, and then all of a sudden you end up and you're very different in different places, and our states are different in different parts of the country, and there are things that we absolutely need to be consistent on. There are floors of things and ceilings of things, but I think people do like the flexibility in the middle of that.
Great. Well, we are at 10 o'clock, and so this concludes our panel. Don't forget to sign out if you're in one of those states. Thank you, everyone, for your attention. May I have a round of applause for this great panel.